All right, call the case of United States versus Larrimore. Mr. Is it Dusenberry or Dusenberry? Dusenberry. We'll hear your argument.
Good morning, Your Honors. May it please the court, I'm John Dusenberry for Joshua Larrimore. It's my contention that the only issue...
Hold on a second, Mr.
Yes.
Dusenberry. Let's wait for folks to file in here. Thank you. Go ahead, sir.
Yes. I maintain, Your Honor, that the only issue presented in this appeal is whether Mr. Larrimore's possession of the firearm in this case facilitated the theft of the firearm. Because that's the issue, it's important to note, I think at the outset, that that is by its nature a nuanced, case-specific factual determination. And because it is, questions that pertain to the elements of burglary, statutory or common law, and the similarities or differences between those elements and other crimes, whether it's larceny or safecracking, are at most interesting, but ultimately beside the point. The district court erred, I contend, in four specific respects that I can identify. First, it employed a categorical approach in resolving what is, as I mentioned, ultimately a fact-specific determination. Clearly, blunt, and all of the cases prior to the guideline amendment turn on or make clear that whether and to what extent a firearm is used in connection with another felony offense is specific to the facts of that case. That was the rule before blunt, or that was the rule before the guideline amendment. That was also, as this court has repeated in Hampton. And
so, looking at the facts of this case, how is the theft of how's the firearm not in connection with the theft? It was the object of the theft.
And that, in my contention, Your Honor, it's precisely because it's the object of the theft that, and nothing else, that it was not actually used in any way other than being the object of the theft.
It facilitated the theft, didn't it? How can you steal the firearm without taking the firearm?
That's the point, Judge.
But it doesn't have to be used to brandish or to threaten. It can actually just facilitate the offense itself, right?
But I think to facilitate means that it somehow renders the firearm possession offense more dangerous. That was a part of the preface of the blunt panel.
But if that's the case, then if Blunt said that, that's true. You're right about that, sir. But the change to the guideline and the analogy, I believe the reason Judge Osteen, ultimately he had some concern about it, but the burglary, the commentary, the application note commentary after the change in 2006 made it very clear that for burglary, you break in with the intent to do whatever you're going to do as a felony, and then that's the completed offense. You open it, you take the gun, and that's all that's necessary. It doesn't have to have anything further than that. And although Judge Osteen pointed out correctly that under North Carolina law, there is no intent acquired with safecracking, but the other elements of it are certainly the same as burglary, or breaking and entering without authority. And if Blunt is changed by the change in the guidelines, how is this different than the nature of just completing the crime of safecracking and then taking the gun from that? How is that any different than what they said for burglary?
The guideline amendment essentially defines the issue of in connection with, out of existence, in the context of burglary, but only in the context of burglary. It categorically declares that irrespective of the specific facts, if a firearm is taken during a burglary, then it is possessed in connection with the firearm offense. But it does not foreclose the rest of the Blunt analysis in terms of what in connection with means. The Blunt's determination that in connection with in this circuit has a more narrow meaning, requires a much closer nexus between the firearm, the gun offense, and whatever the object offense is. That remains intact. That is undisturbed by the guideline
I
amendment.
suppose your point is it would have been a simple matter for the Sentencing Commission to add larceny or a theft offense if that's what they wanted to accomplish.
That would be my position, because in the effect, as I see it, of the guideline amendment as it relates to burglary is to turn what had theretofore been as I said, a case-specific factual determination into a categorical determination as it relates to burglary. But that categorical determination does not go beyond burglary. Crimes of larceny, safecracking are not within the context that's foreclosed by the amendment. Hence, I mean, clearly the Sentencing Commission could not overrule this court's Blunt ruling. It simply eclipsed the holding in Blunt as it relates to burglary. But in terms of the analytical underpinnings that bring you to whether in a particular case a firearm is possessed in connection with another offense
What
or
about the
not.
contention that the firearm could potentially have facilitated the offense in terms of, I mean, in this case, the facts are that your client hid the gun,
Yes.
the weapon. So there was an interim of time where potentially he could have run into somebody else and the situation could have escalated. Isn't that the kind of concern that we have with respect to firearms and facilitating or emboldening an actor to commit another offense?
I think not, Your Honor. But in fact, I think they're directly at odds with the kinds of scenarios that this court has shown concern for, because I think it's particularly instructive to note that in Blunt, the court identified examples of facts which, although absent from that record, had they been present, might have led to a different result, such as keeping the gun close at hand. Well, here we have the very opposite. The defendant hid the gun in a remote location. In Hampton, you've got the defendant attempting to access the firearm when he's being in the process of being arrested.
What would have happened if he had, after the police officer went outside and got in the computer to start the report, and then your client decided that he was going to go back into the safe and take the firearm, which he then hid in the backyard? What would have happened if, as he is walking out of where the safe was to take it to hide it in the backyard, the police officers had come in and seen him with a gun? At that case, don't we have exactly the situation that Judge Diaz made reference to in terms of how it ups the ante in terms of the danger of the situation?
Well,
The fact that it didn't happen doesn't mean that it was not something that could foreseeably happen, and that's, I think, what we have to keep in mind, isn't it?
I think not, Your Honor. I don't think that these type of provisions, which tend to clearly in the preface to the analysis in Blunt, where the court notes that the objective, the purpose of this +4 adjustment is to ensure that greater punishment is imposed on people who engage in conduct with firearms that makes the conduct more dangerous than it would otherwise have been in the absence of the firearm. The scenario, the hypothetical scenario that the court poses, I think is, because of its hypothetical nature, is beyond the scope of what this adjustment is intended to reach. Because, in fact, I'm not aware of any case in which hypothetical facts that did not in fact exist but which might have existed, resulted in the sustaining the imposition of this adjustment. Because when you look at the facts that actually occurred, they were, I would contend, 180 degrees out of phase with the type of behavior that is intended to be addressed by this adjustment. Take hiding the gun, placing it in a remote area, not employing the gun in any fashion to address the police officer. In fact, not according to the evidence, didn't even access the gun until after the police officers had already left, after having spent several minutes in the presence of the officers with the safe open. The notion of facilitating escape or the possibility of a violent encounter. Well, here he was in his own residence, or at least a residence where he was staying with the permission of the owner. So none of those scenarios present themselves on the specific facts of this case. So I would contend that to say that the +4 adjustment applies here not because of anything that was actually done, but because of what might have happened, I think would be a departure from the analytical precedents that precede us. They all, Blunt, Hampton, Alvarado Perez, and other cases, even unpublished cases, all turn on the facts of that specific case. The guideline amendment categorically carves out an exception where the specific facts don't matter as it relates to burglary. But as in any other context, in any context that's other than burglary, where the facts are rendered irrelevant, well, maybe a bit of an overstatement, but where the facts are not the determining the facts are not dispositive. In any other context, it is a purely factual determination. And here, the facts do not satisfy the requirements as laid down in Blunt.
So your position is that Blunt, the 14B amendment notwithstanding, that Blunt remains good law with respect to the facts of this case?
Absolutely. Absolutely.
And the analysis in Pizur, which the government cites the Safe Circuit decision that essentially says if you're facilitating the offense, if the firearm is the object of the offense, that's just not appropriate under our standards in the Fourth Circuit.
I think not, because and I think primarily because it is purely categorical in nature. It is not fact specific, but I also think it's problematic because it's logically. I think it rests on an invalid logical premise. I don't think that the mere existence of a firearm can facilitate its theft any more than the existence of a homicide victim can facilitate.
Except that he didn't break into the safe just to get whatever was in there. He broke into the safe to steal firearms and then to sell them. That's what he said.
I think that's not quite correct, Your Honor. As I recall, he broke into the safe to steal money. Finding none, took a firearm with the intent of turning it into money. His drug problem was really at the core of all this behavior, and I think we actually called his brother as a witness at the sentencing hearing. The brother said the brother is the person who was called saying, "I've got these guns. What do I do with them?" And rather than following his brother's advice, he actually who suggested he call the owner, apologize, ask for forgiveness. Mr. Larrimore called the police and concocted this scenario. So I see that my time is about up. Thank you.
Thank you very much. Mr. Cochran?
May it please the court, my name is Drew Cochran. I represent the United States of America in this case. And this is as the court has heard through the briefs and through argument at this point, an issue of a guideline application where we have the sentencing guideline for firearms 2K2.1 that calls for a 4-level enhancement anytime a defendant possesses a firearm in connection with another felony offense. And what's at issue is what does it mean for it to be in connection with? And in this particular case, there were 2 distinct felonies under North Carolina law that Judge Osteen considered at the district court level to determine whether or not that offense, that guideline application would apply in this case. And those felonies were safe cracking, which was the original justification put forward in the pre-sentence report, as well as larceny of a firearm. Now, those were the two cases, the two felonies that the district court considered in that case. And Judge Osteen found that the defendant possessed the firearm in connection with the felony offense of larceny of a firearm, but declined to apply it to the felony offense of safecracking. And I think that given the posture of this case, and where it is at this point where the district court found that in connection with the larceny, but it declined to find that with respect to the safecracking, that the larceny is probably the stronger case at this point. And there's enough evidence, since the issue was presented to the district court, where this court could affirm it on the alternative ground of the safecracking. But I do think that the larceny is the stronger case at this point, given where we are. It's also worth noting at this case that some of the facts that I believe the court is somewhat aware of, but this defendant broke into a safe and found that there were firearms in that safe. At that point, he hatched a plan, if you will, at some point after
Was it
getting
a gun safe?
It was a safe that contained guns, Your Honor. There were the record shows there were 6 firearms in the safe. It may have been a gun safe. It may have contained other things as well. We don't know that for sure.
The pre-sentence report indicates it was a gun safe.
I think that's probably correct, given the number of guns that were there. The police officers, when they arrived at scene, they called the owner of the guns and spoke with him, and that's how they knew how many guns were supposed to be in the safe, which was 6 and at the time that there were. So after the defendant interacts with the officer went back to his patrol car to begin to generate a report. Somewhere after that, the defendant took a firearm with the intent of selling it, is what he had admitted to officers after he was questioned about that. And he hid the gun underneath a car that was parked outside the house with the intent of getting it back later. And of course, the officer comes back, realizes that one of the guns is missing, and the defendant was the only one who had been in the house. And that's where the whole investigation went from that point. And I think that when we look at sort of the landscape of where the case law was, when we were looking at the burglary context, which is relevant to look at in this case, for a long time there was a circuit split on the issue as to what would happen with this 4-level increase for possession of a firearm in connection with another felony offense for a defendant who, during the course of a burglary, finds and steals a firearm. Some circuits were of the opinion that just taking that firearm in the course of a burglary made it in connection with the felony offense. And this circuit held in Blunt, and this court held in 2003, that a defendant had to do more than just take the firearm, but had to keep it on his person in order to facilitate an escape or use it in some other way to in furtherance of the crime, other than just stealing the firearm. And that led to the application note 14B that was added in 2006 to resolve this circuit split. And application note 14B says that the guideline applies in a case in which a defendant who, during the course of a burglary, finds and takes a firearm, even if the defendant did not engage in any other conduct with that firearm during the course of the burglary. That application note seems to overrule Blunt to the extent of, in the burglary context and in cases similar to burglary. There's a second part of that note that deals with.
Well, let me stop you there. Cases similar to burglary. That's not what the application note says. It says it's limited. I read it as limited to the traditional common law offense of burglary. Period.
Yes, Your Honor. That's the way it's worded, and I think that.
Words matter, right?
Yes, Your Honor, they do, and it does matter. And I think that one of the things that the court needs to look at in this case is the defendant's conduct and what he did, and whether it's something that's supposed to be considered under the application note, or if it's not, then it's considered under the previous holding of Blunt. And I think.
But the point I think is key, and Judge Osteen was honed right in on that at the hearing, is that the elements of safecracking, there's a certain level of similarity between common law burglary and safecracking, in that you're breaking into some closed area without authority. But he asked about and noted that the elements of safecracking under North Carolina statute do not require intent, and that's why burglary was singled out the way it was, isn't it, in the application note, because it's the breaking and entering of a dwelling house at night with the intent to commit a felony. It is a completed offense once you enter the close with that intent. And you can't just say that you can't write out of the importance of what was done in that application note the key factor of what intent does to a common law burglary, which is not the same for a safecracking, despite the fact that there's an illegal entry aspect to both of them, right? How can you can't just eliminate that as a sleight of hand and say that they meant to broaden beyond burglary in the application note change to any offense that has some similarity with burglary.
That's correct, Your Honor, and that's why the district court found that the defendant possessed the firearm in connection with the larceny as opposed to the safecracking.
But doesn't the analysis that existed in Blunt about what is necessary? I mean, there was a very deliberate analysis in Blunt. It was not that we looked at the Fifth Circuit's analysis and said, no, we're not going to go there. They looked at the Sixth Circuit and said, no, we're not going to go there. We think more is necessary. And if Blunt was a burglary case, and if Blunt was the effect of Blunt was intended to be changed by the application note, then don't we have to still apply the remaining language of Blunt in a non-burglary context?
This court, since the application note has changed, this court has looked at applying Blunt in two different cases. One was in Alvarado Perez in 2010, and that involved a Maryland reckless endangerment statute. And the second time was in 2010, the Hampton case, and that was a South Carolina assault statute. So those are things that are, far and away removed from burglary. And I think what we're dealing with here with the larceny and with the safecracking is much closer to burglary than they are to an assault or a reckless endangerment. And I think that's a key distinction. The conduct that's described in application note 14B, where the burglary defendant breaks into a dwelling house and steals a firearm in the course of that burglary, that defendant under North Carolina law would have committed the offense of burglary, but also would have committed the offense of larceny of the firearm. And even though that's not addressed, directly in the application note, it doesn't say and larceny of a firearm. But I think that's important when we're trying to decide, into which analysis the court is going to apply in this
Wouldn't it
case.
have been the easiest thing in the world if that's what the Sentencing Commission wanted to do, is just to expand they specifically referred to it as burglary, and they could very easily have said theft offenses or larceny offenses, but they didn't.
That's true, Your Honor. But we contend that the conduct that they're describing in that application note is close enough to what is on hand here that this conduct should apply to. But I do think it's also worth noting, though, and this is, I think, a big point in this case, is that whether we look at, the court wants to analyze this through application note 14B, or whether this court wants to analyze the case through the holding of Blunt and apply the Blunt reasoning and the Blunt analysis to this case, that either way the district court did not commit error in this case with the larceny offense. The Blunt case, as I said before, it doesn't rule out that a defendant who steals a firearm in the course of a burglary would have that, would never apply in that case.
You mean during the course of a larceny?
Blunt dealt with the burglary, so I'm talking about burglary in this case, but it works with...
Blunt here to these facts, and it seems to me that if we're applying Blunt, then traditionally what we look at is whether the firearm was used to embolden the actor or somehow facilitate another offense, not in the sort of circular way that it's being applied here.
Yes, Your Honor, I agree with that. And what the district court found here, one of the things that the district court found is that the defendant possessed the firearm and it facilitated the offense in two separate ways. One was what we've already talked about a little bit as being the fruit of the theft. The second way that the district court found that the defendant's firearm facilitated the offense was to assistant escape or to facilitate escape is the way that Judge Osteen phrased that. And I think that's important in this case. And the district court didn't specifically say what was meant by that, but I think it can only be applied, as Your Honor was asking previously of defense counsel in this case, that it have to be in the context of that the police officer was already at the scene and the defendant took the firearm at that point and took it up all the way from the gun safe up to the car and placed it behind the car. And anyone that he would have come into contact with at that point, between the safe and the car, he could have used the firearm to facilitate his escape at that point. And that was a factual finding by the court that's reviewed by this court for clear error. And I don't think that we can find that it's error clear or otherwise. And so in that context, even applying blunt in this case, the district court did not commit error. So I do think
That seems to be an odd facilitation, given that he ended up ditching the gun and hiding it. I mean, it seems to run counter to your conclusion and the district court's conclusion that somehow it facilitated his escape.
Well, Your Honor, obviously the defendant's primary purpose for taking the firearm was not to facilitate escape. It was to steal the firearm. But he had to have it at his hand when he was leaving with it, and it could have facilitated his escape, which was all that was really necessary in this case. I also think it's important along those same lines that, according to the defendant, he was obviously going to go back and take this firearm and go and sell it. So he was going to have possession of it again at that point too. So his plan hadn't come all the way to fruition. He was interrupted in the middle of it. So I think that's something that is worth noting. The district court relied on Pazur, which is an Eighth Circuit case from 2010 that's addressed in the briefs and by the district court. I think that Pazur's reasoning is good reasoning in this case. It's also the only published case that I'm aware of in any circuit that deals with the specific issue that we're looking at in this case. This circuit held in 2003 in the Shaw case, that a guideline application case where a defendant who both possessed a stolen firearm and stole the firearm, he received the 4-level increase for in connection with the felony offense that we're talking about here. And he also received a 2-level increase for possession of a stolen firearm. And in that case, this court was addressing the narrow issue of whether that was impermissible double counting under the guidelines, and this court held that it was not. And so I think that's the reason why that issue wasn't raised. It's already been addressed by this court. So as a side note, I do think it's worth noting that this court did address that in 2003. But the Pazur case in 2010, and that dealt with a defendant who was holding some firearms for a friend of his, said, the defendant's friend said, "Here, hold these for me." He said, "Sure." And at some point, he gets the idea to go in and pawn these guns and make some money. And he received a 4-level increase in that case for possessing them in connection with the theft of the offense. And there was the court looked at the issue there, and it's also somewhat interesting because they deal with the question of when did he actually commit the offense of theft. Was it when he put them in the car to go over to the store? Was it when he actually handed it over to pawn the items? But our case is, it's similar to Pazur, where it's on all fours, where it's dealing with the same legal issue. So I think it's important for the court to look at it in that context. And also, the case that we have here is somewhat stronger factually than the case that the government had in Pazur, because in Pazur there was an issue as to whether or not the defendant actually possessed the guns while the theft was taking place. Whereas in this case, clearly when the defendant was committing the theft by removing the firearm from the safe and taking it up to the car and hiding it behind the car, he was in actual possession of that gun at the whole time. So I do think that the district court was properly relied on the Pazur case, and that it's one that it bears consideration in this case, and I think that it's one that the court should adopt its reasoning and apply it here. I would also point out, I think something that's worth considering also is the policy considerations that are mentioned in the sentencing guidelines. And what it is that these guidelines are driving for here with applying these guidelines, the same guidelines, to different defendants who have committed similar crimes but have different conduct. What the guidelines say is that proportionality in sentencing through a system that imposes appropriately different sentences for criminal conduct of differing severity. They want to have, the guidelines are looking for punishing people who have committed the same crime in different ways, in different manners, according to with severity. So people who have done more severity are getting obviously higher guideline sentences than people who have less severity. And it's worth noting that the defendant in this case, in order for him to come into possession of this firearm, had to commit 2 separate felony offenses under North Carolina law. He had to commit the felony offense of safecracking, and then he had to commit the felony offense of larceny of a firearm to actually remove that firearm and take it from the safe and come into actual possession of it. And yet he is claiming that his sentencing guideline range should be the same as a defendant who has neither committed the offense of safecracking or the offense of larceny.
There's a separate 2-level enhancement for if the firearm is stolen. That was not applied in this case?
It was applied, Your Honor.
So if your concern is that if I'm a felon and I walk down the street and I see a police officer and the police officer's handgun falls out of the holster and I pick it up and hand it back to him, I'm now a felon in possession. Now, maybe that prosecutorial discretion wouldn't prosecute me for that. I hand it back. I'm about as innocent as I can be, but I'm a felon in possession, all right? Now, contrast that with my breaking in and stealing it. Obviously, those are more severe. The second one, it should get a greater punishment. But why isn't that greater level of punishment associated with the larceny already accounted for by the 2-level increase because the firearm was stolen? If you're worried about this is going to be a person who is not going to have a punishment that reflects the fact that there was a theft, why doesn't that guideline take care of that for you?
The difference, Your Honor, is in punishing someone who is in possession of a firearm that happens to be stolen versus a defendant who himself actually stole the firearm. The 2-level enhancement that Your Honor speaks about, that applies. We see it most of the time in cases where a defendant is in possession of a firearm. You know, the officers somehow find him in possession of it. We don't know how, but they find him in possession of it. We're not really sure how he came into possession of it, but they run the serial number through the database that they have that reports stolen items, the NCIC database, and it comes back as stolen. And whether the defendant knew that it was stolen or not, it has that 2-level increase that Your Honor is referring to applies in that case. So what we're looking at here is how do we differentiate that situation, it's a garden variety situation that we run into all the time. In fact, most of the 2-level increases for possession of a stolen firearm are somewhere in that vein. So how do we differentiate that for proportionality purposes under the guideline from a defendant who happens to be in possession of a firearm that was stolen to a defendant who we know in fact stole the firearm? And I think that's where there's the additional 2 levels and then there's the 4-level increase. And that's the situation that we have here. This defendant not only was in possession of a stolen firearm, but he himself actually stole that firearm. And he had to actually break into the safe to take that firearm in the first place. So under proportionality and the guideline applications, his sentence, his guideline range should be higher than a defendant who just happened to have a stolen firearm in his possession. I see that my time is about up here, unless the court has any other questions for me.
Thank you very much.
Thank you, Your Honors.
Mr. Duesenberg, you have some time for rebuttal?
Your Honors, my position is that that if access to a firearm alone without more is sufficient to trigger the +4 enhancement or adjustment under subsection B6, then virtually every felon in possession of a firearm case would have that adjustment applied. It would essentially amount to, I thought initially perhaps a rebuttable presumption, but it would almost be an irrebuttable presumption because there would be no scenario where the defendant's possession of the firearm could not be used if what the defendant might have done with the gun became the operative test. There'd be no scenario where the felon who is in possession of the firearm could not have used the gun to commit another crime. We were talking earlier about the possibility of him having encountered a law enforcement officer or someone else from in the distance from the house to the car where he hid the gun. Well, that certainly is a possibility. But it would create an environment where a defendant would have to prove not only that he did not use the gun in an aggressive or a violent way, that he'd have to prove that he could not have, which would, I think, be a virtual impossibility. I don't think that's what's contemplated. I do understand the government's position in terms of the need to meaningfully distinguish between merely possessing a firearm and the defendant having stolen it. But that is it seems to me that that's a task appropriate to legislation or the rulemaking authority of the Sentencing Commission. To stretch, I would contend, this +4 enhancement of subsection B6 to fit that scenario, I think would just would not be the appropriate response. And it is not my contention that larceny, or even for that matter, safecracking, can never serve as predicates for the adjustment. It merely is I'm simply saying that it's a fact-specific determination. And if the facts of the safecracking or the larceny suggest, in fact, I believe there are cases where the +4 enhancement was upheld in a larceny scenario because of the situation. I remember one case, and I'm sorry, I can't remember the name of it, where a defendant stole a gun in another person's house. Well, the idea about the gun possibly having been used to facilitate an escape because he was in another person's house was used as a basis for upholding it. Here, I think it's significant that Mr. Larrimore was in his own house. So for those reasons, I asked the court to reverse the district court's ruling and vacate the judgment and remand it for resentencing.
Thank you very much, Mr. Duesenberg. All right, we'll come down and greet counsel and then proceed on to our next case.